about how they would respond to this attack on the privacy of their patrons. They would fight like hell. But the decision to fight the federal government, they were informed by the ACLU that the only way to challenge this gag order was to sue the U.S. Attorney General, and the librarians decided to take it a step further. They would challenge the entire basis of the USA Patriot Act, particularly the parts that target libraries, which there are provisions of it specifically aimed at libraries. In so doing this, the librarians lost their name and their voice. They became John Doe, Connecticut. The case was John Doe, Connecticut v. Gonzalez. They couldn't speak about what they were doing, but so as this moves into the legal realm, they have a first trial set for, this is now September 2005. And just in the course of doing this, this gag order ensnared them in every conceivable way. You see, Peter Chase was head of the Intellectual Freedom Committee of the Connecticut Library Association. He had spoken often in that capacity about the dangers of the USA Patriot Act and had publicly debated the U.S. Attorney for Connecticut, Kevin O'Connor. Suddenly, in July 2005, Chase fell silent on the subject. His lawyers advised him that he risked violating his gag order. He said, "I could no longer speak about the Patriot Act because I'd be asked about the case against the librarians in Connecticut. If I said I can't talk about that, it would be like waving a red flag saying, 'It's me, it's me.'" By contrast, U.S. Attorney O'Connor was speaking so often and ardently in favor of the law that he boasted at one forum, "The Patriot Act is my mistress." So while O'Connor traveled the state reassuring people that the Patriot Act was not targeting libraries and would only be used against hardened terrorists, he was silencing one of his most articulate and effective critics by using the Patriot Act against libraries. It was a diabolical deception worthy of Kafka. Now, to fully appreciate this, I just want to give you a picture of what these librarians, how they come across. When Amy and I met, we met with Peter Chase and another of the Fab Four, a librarian named Janet Nocek. We were met at Peter's library. It was just as the library was closing. He is your stereotype of the community librarian. Extremely polite. Greets us at the door. He's got a jacket and tie and a little gold badge that says Library Director. And he takes us around the library like a doting parent, showing off the beautiful, children's collection and the computer technology that used to be private and inviolable and all that. And the only time that the smile leaves his face is when we enter and ask to bend the rules a little by bringing in loaded coffee mugs. And he kind of looks over both shoulders and shoos us into his office in the basement. So these are now the people who have been dubbed four of America's most dangerous terrorists under the law. Well, we proceed to trial. So they're looking forward to their day in court. It's a right been enshrined in our Constitution and Bill of Rights for a couple of hundred years. We hope for a few hundred years more. But their lawyers call with some strange news. They can't attend their trial. They have been branded a threat to national security, the four librarians, and the Justice Department has demanded that they not be present. And so while the trial gets underway in Bridgeport, the four librarians, the plaintiffs, are herded into a storage room in a federal courthouse in Hartford, 2 hours away, locked in a storage room and forced to watch their own trial by closed-circuit TV. It sort of reminds you of that part in Tom Sawyer, I think it is, or Huck Finn, where they go and watch their own funeral from the back, but they can't participate. And they hear all these wonderful things said about them. So, at the courthouse in Hartford, the security guard did sort of think it was a little strange that he was locking these librarians in a closet, but, they're trained not to ask too many questions. So they see two things from the in the closed circuit TV. The TV gives them a view of their trial that is the view that I have of you. It is over the shoulder of the judge looking out on the audience. So they see these two things. One is that U.S. Attorney O'Connor making the case about why libraries are now the front line in the war on terror. The other thing they see in that courtroom is that it is packed with librarians from around the state. Word was out, not about who was in the dock. Nobody knew, and the librarians were very careful to guard their privacy, to obey the gag order. But their word was out that some national security case was being lodged against librarians. Well, they won that round, and then they quickly lost the round because the government appealed, and the gag order was reimposed, but the government made a very clumsy error. The judge said that, look, you can't just have a major case like this and say absolutely nothing that it's about, and force the government to release a little information about what it was about. In so doing, the government released a bunch of papers and failed to redact every instance of the name of the library connection and of Peter Chase's name in particular for some reason. And so Peter gets a call a day or so later after these court documents are released. It's a reporter from the New York Times, and she asks him a simple question. Are you John Doe, Connecticut? He hangs up the phone. He thinks this is rather funny. Here the government has gone to such great pains to say that their names must be kept secret because they could be terrorists, and they go and blow the case themselves. Well, he calls his lawyer and tells them this, humorous little event, and there's silence on the other end of the phone. And the lawyer finally says, Peter, this is a very serious matter because it would be a very simple thing for the FBI to learn, if they haven't already, that a call was placed from the New York Times to your home or whoever placed that call. And if your name comes out in the newspaper tomorrow or this week, they would have to assume that you broke the gag order. And if you broke the gag order, you know what the consequences are. So I would recommend that you leave your house and you start staying with friends and change locations regularly so that papers can't be served on you or that you can't simply be arrested. So now Connecticut's librarians are bound, gagged, and on the run. The case continues. It goes to federal court in Manhattan. And now there's good news. Just as the founding fathers and mothers could 200 and some years ago, they can now attend their trial. Their lawyers inform them. But their attorneys say, could you please not look like librarians when you come to court? You still have to guard your privacy. We suggest, why don't you look like lawyers? Because lawyers are always coming to these courthouses, and then maybe no one would notice. So Peter takes out the black suit that he reserves for funerals, puts it on, and says he tries to look very dour and grim. They also are under several other instructions. Do not come to the courthouse together, lest anybody think that you are the Fantastic Four. Do not look at your attorneys when you're inside the courtroom, so that nobody suspects that we are with you. Also in that courtroom will be John Doe, New York. It is another case we are representing that has been joined with yours. It is a small internet service provider who is refusing to provide information on his customers that the FBI is demanding. John Doe, New York will be in the courtroom, and you will be in the courtroom. You will not know who each other are. To this day, they do not know who John Doe, New York is.